Mr. Gura, first, I'd like to thank you for your courage and your efforts in finally getting the Second Amendment properly defined. My question is actually somewhat related to the first one that you had. As a veteran, I realize how absurd it would be for the United States citizenry to stand against the United States military, and recognize how ridiculous the notion of even somebody with Bill Gates money owning an aircraft carrier is. However, I wonder, what does this do to the idea that one of the core reasons for the Second Amendment is to protect us from a government that's grown tyrannical?
Well, I think the court did recognize, in its opinion, that resistance to tyranny is a reason for having the Second Amendment. The court later in the opinion mentions that, well, even if it's not necessarily always going to be practical to rise up against the U.S. military, that's not our problem. That's a circumstance which may or may not have overtaken the Second Amendment, but the Second Amendment is still there. My own personal view is that if the United States were to suddenly fall under the spell of some tyrant who were to, say, suspend the courts and cancel elections and put people in cattle cars and stuff, I mean, if we were to have a really bad government, I do think the Second Amendment would be useful. And I think that even in today and a few years ago in the 20th century, we've seen populations in other parts of the world cause a lot of grief to the U.S. military using small arms. Of course, it's sad from our perspective. From their perspective, it's a little different. But definitely, the court still recognizes that there is this historically accepted concept that the Second Amendment is there to safeguard us from tyranny. And it's not what the other side claims. The other side always says, well, this is the insurrectionist theory of the Second Amendment. You guys are all traitors and you want to overthrow the government. Nonsense. If you read Justice Story's treatise from the 1830s, if you look at what all the early framers said and people for whom the framers were in living memory, they viewed the idea of a citizen militia rising up against a tyrant not to be a right to revolution or a right to insurrection, but rather a means by which people restore the constitutional order. That is, if a tyrant were to usurp the Constitution and to start doing things that are totally inappropriate, then the right to arms would be the means in which we would restore the proper order of things. In fact, that's why during the Revolution, the folks on our side would call themselves patriots. They felt that they were the ones who were being faithful to the rights of English subjects. It was the Parliament and the King who were somehow abusing long-held traditional rights of English subjects.
Alan, congratulations on the outstanding job you did in preparing and presenting the case. I was surprised at how close the decision was, and I was curious about your judgment as to the stare decisis value if one justice, if Scalia were to retire and be appointed by a more liberal justice. What's your judgment about how likely this is to be narrowed or overruled?
Well, that's a great question. I was personally surprised it was 5-4. I thought the case is much stronger than that. I was disappointed that we only got 5. Of course, I'm happy that we got at least 5. So I'll take the 5. It is disturbing that 4 members of the court signed on to these dissents. The court does give stare decisis a role, as well it should to some extent. That is that people have a right to settle expectations in the law. One of the values of having these opinions in the first place is to give people predictive value. But that's not to say that a really terrible decision needs to stand the test of time just because it's there. And of course, Plessy versus Ferguson, of course, is the one that people like to point out all the time. That was derided as being wrong the day it was decided, and it was. And I don't think it should have remained the law just because it had been the law. Some people may take that view of Hellar, and I think that would be sad. I think we have to be careful. We have to make sure that the people who are nominated and confirmed to the federal courts respect our rights and respect the court's role in enforcing those rights, not by showing sort of slavish obedience or deference to the political branches whenever they do what they will, but rather understanding that it's the third branch of government, it's the only branch of government which actually reads and cares about the Constitution in a meaningful way and will apply it. So it's interesting. I do believe that, just based on what I've seen in the few days since the opinion, that people will start using Hellar as a litmus test. I mean, we've had people using other cases that way. I'm now getting email and stuff saying, "Oh, I'm going to write my senator to make sure that he only confirms people who believe in Hellar." That'll be interesting. It's definitely part of the debate on nominees.
Thanks again for coming.
Thank you.
The Consumer Product Safety Commission does not now have the ability, and it has not had the ability, to regulate firearms. And I read the majority's opinion as being somewhat broad in terms of what they describe to be potentially permissive regulations of firearms. Do you see that broad language? I guess, do you agree with me that it's somewhat broad? And do you see the breadth of that language as perhaps enabling someone to make an argument that now the firearm can be regulated as a consumer product by the Commission?
Well, I don't view the opinion as calling for broad regulation at all. I think the opinion acknowledges that normal regulations are going to be upheld. Bans on lunatics, for example, carrying a gun in an airport, I think, is going to not be allowed. But guns are a consumer product, quite obviously. Nobody wants to have guns which will blow up in your hand or perhaps not function when you really need it to defend your life. So, I could see a role, whether it's the federal government, I'm not so sure, certainly sometimes for state government, to make sure that the gun operates as is designed, doesn't blow up in someone's hand, basically is going to pass an easy, a drop test that's not too onerous. I do not believe that guns can be regulated as a consumer product in such a manner as to abolish them or make them impossible. I don't believe that we can see regulators imposing what I call these science fiction requirements on guns. We need a gun that will only shoot bad guys, that the bullet will somehow not hit anyone who's not supposed to get hit, sort of a psychic gun. Those things, you see some gun prohibitionists trying to craft laws like that, and I think those are not constitutional. People have a right to weaponry that they would normally want for self-defense. If it's, basically functions as it's intended to, which, yes, of course, it's dangerous if you shoot the wrong person. It's not a good idea. But no, there's some role for regulation, but it's not a huge one. It's a common sense one.
Alan, what is the present stance in Chicago on gun control, and do you have that city in your sight, so to speak?
Yes, I do. If you visit www.chicagoguncase.com, you will see a website that my co-counsel and I have set up. I filed the first challenge to the Chicago handgun ban as well as to certain of the Chicago registration requirements, which we believe to be onerous and impractical. I know that NRA has also filed a lawsuit there. Other people might yet join the party. Chicago's laws are the ones that everyone looks at because they're so similar to Washington, D.C., as they have a handgun ban. And so if the Second Amendment is incorporated through the 14th Amendment, then at the very least, Chicago's handgun ban cannot survive now after Hellar. So that's going to be interesting litigation to watch.